Good morning. Number 1, I was hospitalized for 5 days due to chest pain and according to the doctor, hindi daw siya pwedeng mag-issue ng fit to work unless nakapag-angiogram daw ako. Can my employer dismiss me for not submitting the fit to work required by the doctor? And number 2 is most of my ill experience I've got was due to stress brought about my attitude of the assigned boss. Pwede ko ba siyang sisihin? Yun yung question, sir, ni Mr. Lopez.
Okay, so very complicated yung question. Isa-isahin natin, no? Himayin natin, no? About fit to work. Fit to work is not a ground to terminate an employee. Hindi po yan valid ground. Pero pag hindi po nakapag-produce ng fit to work, pwede pong sabihin ng employer na huwag ka muna mag-report. No? But it's not a ground for dismissal. It's merely a basis for an employer to tell the employee, wag ka munang mag-report kasi baka may mangyari pa sa iyo, di ba? It's just a show of concern. Yan po ang purpose of the fit to work. Kasi baka what if sa opisina ka pa abutan, baka lalong lumala pa yung condition mo, mas stress ka, di ba? Work is stressful sometimes with all the deadline and the commitment and all the obligations, no? Now, kung gagamitin ang health, no, pwede bang ma-dismiss ang isang employee due to health reasons? Yes. However, hindi po ganun kadali yon. Hindi ganun kadali na hindi ka lang makapag-issue ng makapag-produce ng fit to work kaya madi-dismiss ka na. Under the Labor Code, Article 299 of the Renumbered Labor Code and its implementing rules and regulations, the employer is allowed to dismiss an employee. However, there are several conditions. Number 1, kailangan may medical certificate from a public health authority, meaning government hospital, government clinic, or government doctor who is expert on the particular illness or disease. Mag-i-issue siya ng medical certificate that the condition of the employee is such that the illness or the disease cannot be cured, cannot be treated, cannot be rehabilitated within a period of 6 months, even though there's an adequate medical attention or medical treatment. No? 6 months na hindi gagaling si employee. At within that 6 months period, the employee cannot be given a fit to work. No? Hindi makakapag-report si employee within that 6 months period at hindi siya magagamot within that 6 months period. That will give the employer a valid reason to terminate the employee. However, kailangan pong may separation pay. Separation pay equivalent to half-month pay, half-month, kalahating buwan na bayad na equivalent to separation pay for every year of service. Ayan po ang nakalagay sa Labor Code. And of course, the employee should also be given due process, 30 days notice, plus the employee must be allowed to be heard to explain himself, ano ba itong situation mo, may gusto ko bang masabi, so kailangan po may 2 notice rule, plus 30 days notice, plus separation pay. Yan po yung procedure na sinabi ng Supreme Court. In-outline po yan ng Supreme Court sa isang landmark case, Dioferio, Mr. Dioferio versus Intel Technology. At nandyan po, sinulat po ng Supreme Court yan sa decision na yan, yung mga procedure, yung proper procedure on dismissing an employee on the ground of health issues or health concerns. Now, in this particular case, si Mr. Dioferio is suffering from a mental condition. May mental illness po siya, diagnosed po siya ng doctors from the PGH, no, Philippine General Hospital, and that's why sabi ng Supreme Court, valid po yung ginawa ng Intel Technology na i-dismiss si Mr. Dioferio kasi hindi magagamot yung kanyang mental condition for a period of 6 months kahit na may adequate treatment, and within that 6 months period, he cannot be given a fit to work because he's showing symptoms, he's showing signs of itong mental instability niya that is causing harm, causing panic, no, na naprapraning, natatakot yung mga co-employees, no, and he throwing tantrums, hearing, may mga napapakinig siya ng mga voices in his head, no, mga ganon. So natatakot yung mga tao around him. So that's why sabi ng Supreme Court, allowed. Okay, so yung another question naman, yung last question ni Mr. Lopez, kung pwede ba niyang pagbayarin yung employer niya o yung boss niya sa kanyang pinagdaraanan dahil apparently the reason why he's suffering from this condition is due to work. Pwede po, no? But you have to prove it. You have to prove. Pwede naman po. There's a possibility. Also, kung ito po ay work-related, actually pwede po kayo mag-claim sa SSS, pwede po kayo mag-claim sa Employees Compensation Commission for work-related illness or injury. Nagbibigay po sila ng compensation sa employee. So, either you can work with your employer for your claim with the SSS and Employees Compensation Commission, or you can go straight po sa Department of Labor and Employment to file your complaint. No? However, you have to prove your case against your boss or against your employer if you suspect, if you believe that they're the one who caused your illness. Okay? So kung may follow-up question po kayo, just send it po dito sa ating message, at kung may time po tayo, we will answer your follow-up question, Mr. Lopez.